Most of the time, you can avoid resisting arrest charges by politely complying with an officer's requests, even if you feel the arrest is unjustified. This is usually the best move, since if things escalate, you could end up charged with assaulting an officer, a much more serious charge, usually a felony. However, if you do find yourself charged with resisting arrest, a knowledgeable criminal defense lawyer can evaluate your best options. Most state laws prohibit you from resisting or delaying police officers or EMTs who are trying to perform their duties. Doing so is considered resisting arrest, a misdemeanor. It usually involves physical force, but not always. Depending upon the circumstances, you do have options to defend yourself against these charges. Resisting arrest is usually defined as intentionally preventing an officer from lawfully arresting, handcuffing, or taking you to jail. Here are some things that can be considered resisting arrest. Physical acts, such as running away, hiding, or struggling with an officer. Giving false identification, either verbally or by presenting a fake ID. Trying to help another person avoid arrest. Threatening the officer. Being slow to comply with an order or swearing at an officer is not, by itself, usually enough to warrant resisting arrest charges. Neither is questioning an officer's actions or authority before ultimately complying with requests. The key to defending yourself against resisting arrest charges is to remember that such charges hinge on you resisting an officer of the law in the lawful execution of his or her duties. Here are some possible defenses depending upon your situation. Unlawful arrest. If the arrest was not lawful to begin with, you did not do anything wrong, even if you did resist, the officer was not performing his or her duties, since there is no duty to make an unlawful arrest. An example of this is resisting during an unlawful search of your home. Self-defense. You have the right to defend yourself against police misconduct. An officer using excessive force against you has changed the arrest from lawful to unlawful. Keep in mind that if the officer's use of force was in response to forceful resistance from you, you lose your self-defense claim. Also, your response has to be reasonable given the circumstances. You cannot break free and start hitting the officer. False allegations. This defense hinges on proving that nothing you did fits the definition of resisting arrest. For example, you were simply rude or sarcastic, and the officer decided to retaliate by filing resisting arrest charges. It helps to have other witnesses to prove this. The officer did not identify him or herself. It is not possible to intentionally resist an officer if you do not know the person is an officer. An example would be an undercover officer who did not verbally identify him or herself. Citizens may resist unlawful arrest to the point of taking an arresting officer's life if necessary. This premise was upheld by the Supreme Court of the United States in the case John Bad Elk v. U.S., 177 U.S. 529. The court stated, "Where the officer is killed in the course of the disorder which naturally accompanies an attempted arrest that is resisted, the law looks with very different eyes upon the transaction when the officer had the right to make the arrest from what it does if the officer had no right. What may be murder in the first case might be nothing more than manslaughter in the other, or the facts might show that no offense had been committed. An arrest made with a defective warrant, or one issued without affidavit, or one that fails to allege a crime is within jurisdiction, and one who is being arrested may resist arrest and break away. If the resisting officer is killed by one who is resisting, the killing will be no more than an involuntary manslaughter. When a person, being without fault, is in a place where he has a right to be, is violently assaulted, he may, without retreating, repel by force, and if, in the reasonable exercise of his right of self-defense, his assailant is killed, he is justified. These principles apply as well to an officer attempting to make an arrest, who abuses his authority and transcends the bounds thereof by the use of unnecessary force and violence, as they do to a private individual who unlawfully uses such force and violence. An illegal arrest is an assault and battery. The person so attempted to be restrained of his liberty has the same right to use force in defending himself as he would in repelling any other assault and battery. Each person has the right to resist an unlawful arrest. In such a case, the person attempting the arrest stands in the position of a wrongdoer and may be resisted by the use of force, as in self-defense. One may come to the aid of another being unlawfully arrested, just as he may where one is being assaulted, molested, raped, or kidnapped. Thus, it is not an offense to liberate one from the unlawful custody of an officer, even though he may have submitted to such custody without resistance. Justice Joseph Story of the Supreme Court affirmed the right of self-defense by persons held illegally. In his own writings, he admitted that a situation could arise in which the checks and balances principle ceased to work, and the various branches of government concurred in a gross usurpation. There would be no usual remedy by changing the law or passing an amendment to the Constitution, should the oppressed party be a minority. Story concluded, if there be any remedy at all, it is a remedy never provided for by human institutions. That was the ultimate right of all human beings in extreme cases to resist oppression and to apply force against ruinous injustice. As for grounds for arrest, the carrying of arms in a quiet, peaceable, and orderly manner, concealed on or about the person, is not a breach of the peace, nor does such an act of itself lead to a breach of the peace. You are also within your rights not to answer any questions without a lawyer present, and if possible, to demand a video recording be made of the entire encounter that you or your lawyer keep as evidence, so that federal prosecutors can't get away with charging you with making false statements to a government investigator. If you found the information in this video helpful, please like and subscribe to this channel. The Self-Defense Fund is the only one that will fight for you all the way to the United States Supreme Court and cover you for both criminal and civil cases.